Have you ever been sued or been concerned about a lawsuit taking all or much of what you've worked so hard to attain? Most adults have. And if you have had this concern, this video is for you. This is because we're going to talk about what items that you own that can be and what cannot be taken away from you when somebody wins a lawsuit against you. So watch until the end and you'll have some great ideas about how you can protect yourself from having to live under an overpass drinking cheap wine out of a paper bag. Besides, it gets awfully cold out there and the 18-wheel is above your head can make it kind of hard to sleep. So if you enjoy sleeping in your nice warm comfy bed in the winter and you want to keep it that way, keep watching. Hi, I'm the business guy, the CEO of Asset Protection Planners and Lawyers Limited, the nation's largest firm that protects assets from lawsuits. And if you could be so kind as to seize the opportunity and click the like button right now so YouTube promotes this video, I'd really appreciate it. And if you're new here, you can also click the subscribe button below so that when more videos come out like this, you'll be up to date right away. It can sometimes happen that a creditor wins a judgment against a debtor, but the debtor claims he or she does not have the means, usually cash, to satisfy the debt outright. In this case, the creditor has the option of attaching a claim to the debtor's other assets. This is one of the first steps in their effort to collect the debt. The creditor may win a judgment, but a court-ordered judgment doesn't automatically turn over the debtor's assets. So the creditor must take action to satisfy or discharge the debt. And this is why it is important for you to know what assets can be seized by a judgment creditor, and you should also inform yourself about asset protection strategies that you can use to make forfeiting your assets very unlikely. We have lots of videos on this topic on this channel. So judgment in hand, a creditor has a number of options they can pursue. First, they need to discover exactly what assets can be seized in a lawsuit. So, further steps are taken. And one of the most commonly explored avenues of asset or property discovery is the judgment debtor's examination. This is typically where the judgment creditor's attorney sits you in a room and asks you questions under oath. And it's their job to pry as much information as they can out of you to unearth assets they can seize and hand over to their clients. In this proceeding, the onus of ascertaining the whereabouts of your assets or property they can seize falls on the creditor. Now, it's important for a debtor to understand that assets or properties can mean more than just physical property, such as a house or vehicle. Neither are they limited to that which the debtor currently owns or controls. And it can indeed refer to future property or assets expected but as yet non-existent. Despite the far-reaching, almost all-encompassing definition of property in this case, each state offers a debtor certain exemptions. These fall within certain value limits. If these assets are all that remain in the debtor's possession, these exemptions can render the judgment virtually hollow. And in addition to certain state-sanctioned assets that are exempt from judgments, there are legal ways to protect one's assets. This is especially comforting to know when the judgment, hard-won though it may be, arises from a frivolous lawsuit or a predatory claim. Now keep in mind that some states do and some states do not exempt certain kinds of property. Assets a creditor can seize may include some or all of the following: investment accounts, personal residence, and this is state dependent, rental property, automobiles, business equipment, 25% of your wages, accounts receivable, current or future inheritances, assets recently transferred to somebody else, and assets your spouse owns in community property states. Asset seizure is the creditor's responsibility. Now it's up to the creditor, not the court, to collect on a judgment that he or she received. The creditor must find out what assets a debtor has that he or she can use to satisfy the obligations, assuming the debtor pleads to lack of funds. To do this, the creditor must request a motion for examination of judgment debtor. Now this is important because a judge signing it and a creditor serving it obliges the debtor. They must appear at the examination or risk being held in contempt of court. Now, contempt of court does not mean drinking cheap wine under an overpass, but it does involve bars and not the type that serve whiskey. And the day-old bologna sandwiches will leave you yearning for mama's meatloaf even if you gagged at the sight of it as a kid. At the judgment debtor examination, the debtor will be placed under oath. This means that he or she must answer the creditor's questions truthfully or risk perjuring themselves. Perjury can carry a heavy fine or even jail time. I think we just mentioned that. However, a debtor is not under any legal obligation to volunteer any information about his or her assets. A creditor must ask the right questions. Now, after the procedure, the creditor must file another motion in court, and only then will they be able to attach a claim to the debtor's assets or properties that are not exempted by the state. When mentioning property, most people think only of real estate. They may consider things such as the house where they live, or things they own, such as a car or boat, or cold cash. But property, especially in court cases, can also mean a person's salary. It includes deposit accounts, stocks and bonds, IRA accounts, and other similar types of assets depending on the state. Don't think just because you don't own the house where you live, or have no car, or any type of tangible asset, or don't have a ton of money in the bank, that a creditor has nothing to take from you. A cunning and determined creditor can attach a claim to just about anything you own. This includes properties that you would not even have thought were vulnerable to seizure in a judgment. But if you are ever asked what you do have, don't be like the guy who was dragged into criminal court. The guy was charged with stealing a car, but the judge set him free because there wasn't enough evidence he had committed the crime. On the way out, the guy said, "Thank you, Judge, I'll never do it again." The DA appealed the ruling and got him convicted. Back to property seizure. There are exemptions, of course, and these vary greatly from state to state. For instance, most jurisdictions will allow a creditor to attach your primary dwelling to a court judgment. But even in this matter, there are legal nuances that can mitigate each case, meaning it's possible to lose your house to a creditor in most states. Some people think they can move to Florida and buy a house and they're off scot-free. Now, the problem comes to light when your creditors force you into involuntary bankruptcy. In such a case, your house is 100% vulnerable unless you resided in Florida for the past 40 months. That's 3 years and 4 months. Educate yourself. Once you learn you have a lawsuit filed against you, it's important to educate yourself about the laws in your state regarding your rights as a debtor. Understand what a creditor may be entitled to should he or she win the case against you in court. You'll likely realize you stand to lose more than you first thought. That is, you actually have assets that can be attached to a judgment. Perhaps then, if you have not already done so, you will take action on protecting your assets. The time to convince a plaintiff to be considerate of your situation is before a trial and not after. This is especially when he or she wins a judgment against you. So by putting your assets in the proper legal tools, such as an international LLC and/or offshore asset protection trust, you put yourself in a position of strength. When negotiating a settlement, you have the power. On the other hand, you may decide to hunker down in the asset protection bomb shelter we set up for you. You may just decide to have us set up bulletproof legal tools and not let them get anything at all. Call us at the number below or fill out a free consultation form on our website to speak with one of our staff attorneys or consultants. While it may be difficult to imagine a creditor going after a property you do not yet own, this happens often enough in these types of cases. Again, it helps to understand that property does not just refer to a tangible asset. You may receive commissions as part of your compensation at work. The creditor can attach your future commissions to the judgment against you. A judgment can also seize royalties from a book or film or other type of creative work. The same is true for tax refunds. It can also include most insurance payouts. In some cases, it can even mean income from certain types of trusts or dividends from company shares. Stock options, as long as they are fully vested and assignable, are considered future property too. Therefore, a creditor can attach a judgment to them as well. None of this happens automatically, of course. A creditor has to know what type of assets you own by asking the right questions during the debtor examination. Because as a debtor, you will be under oath during this procedure, you must answer all questions before you as truthfully as you can. Lying under oath can lead to a charge of perjury, as we said, so should you be caught in a lie, this can cause a whole new set of bigger problems for you. Keep in mind, however, that telling the truth does not mean volunteering information that was not sought in the first place. Having won a judgment against you, it is the creditor's task, not yours or the court's. It is up to them to find out precisely how they can enforce the judgment in terms of unearthing the assets they can legally attach with a judgment. Now, there are certain kinds of professions that carry a high risk of litigation. These include careers in medicine, think malpractice suits, or even financial planning, wrong investment advice. However, it is beginning to seem lately that almost any profession can be considered high risk for lawsuits. If you're working in one of these types of fields, or even if you're not, you likely just want to make sure that the assets you have worked so hard for do not fall into the clutches of predatory litigants. So you should consider an asset protection strategy. The best time to initiate an asset protection plan is before somebody files a lawsuit against you. The second best time is when you realize you need it. But the truth is that most people come running to us with their hair on fire. So most people have to feel the pain personally before they act. But even after you've been named a defendant in a lawsuit, you can learn how to protect your assets and then take the necessary action. Now, it may limit your options at that point after somebody files a lawsuit against you, but they are no less effective. Now, no one is being advised to willfully squelch on a legitimate debt or defraud an individual. However, you are within your rights to do everything legally possible to secure the assets that you work so hard for and rightfully belong to you, and whoever you wish to bequeath them to upon your passing. Every state has a list of assets or properties that are exempt from seizure. This can give a debtor a bit of relief. However, the best way to protect your assets from judgments is to have an asset protection plan. It is best if it is in place before the plaintiff lodges a lawsuit against you. But there are a number of financial vehicles and instruments that can help you afterwards. This includes domestic and offshore asset protection trusts, limited liability companies or LLCs, to name just two options. And you'll need some powerful asset protection, especially for determined creditors with deep pockets. Nevertheless, having one or more legal tools in place may just prove to be enough of a deterrent for creditors who have a legitimate claim and a big axe to grind. I'm kind of afraid of axes right now. Thanks for joining me. Please click like, subscribe, and share the heck out of this video. This is The Business Guy.